A disability accommodation is something that the employer works with the employee or potential employee to see if they can actually do the work well on a regular basis. Let's explore what are some of the duties that we have to pay attention to. First of all, you have to have a task and look on the task, what is the fundamental job of that this person is supposed to do. By fundamental, it's not the extra things, not the marginal, but what is the core duties of the job. If the job, for instance, is assembling small parts, and it's a matter of assembling them all day long, but the person has a hard time aligning small parts together, then that person cannot perform the fundamental functions of the job. You have a dialogue with it, and we'll talk about what that means. But first of all, the factors on this are the employer's judgment. Can they really do the work? And you don't want to sit down and have them doing 70% of the work. Can they consistently do the fundamental part of the work consistently throughout the entire day? Okay, the written job description. Of course, in employment law, you better have a good, solid job description that's well done, professionally formatted, and describes the true duties of the job. If it's not clear, okay, that document can and may be used against you in a court of law. So pay attention to what that is. The time commitment to that function. If you're expecting a part to come out every 5 minutes, 12 parts per hour, okay, and you're looking at that is actually your expectation, and the person can assemble only a fraction of that number, then you have a problem. That person cannot execute the fundamental parts of that job. But make certain that that person is producing far less than everybody else. If it's close to being the same as everybody else, you might have the option to maybe sit down and have that person do the job. If they have training or learned how to do it over time, will they be able to do it at the same speed as everybody else? So pay attention to the time commitment. What happens if the parts don't get made? Okay, are there collective bargaining implications? What kind of experience of past employees in that function? If somebody started a job and instead of doing it a part every 5 minutes, if a person with no disabilities, the first time they did the job, it took them 10 minutes per part and they only cranked out 6 parts per hour, not the expected 12 parts per hour. And the person that comes in with a disability, they're doing 6 parts per hour at the beginning of it. You know what? Maybe they're going to overall increase their overall speed to meet the expectations. Don't have a different standard for them because they have a disability. Make certain if there's a problem, that the problem is the same as everybody else's, and also the improvement level might be expected to be the same as everybody else. So pay attention to the current work experience of the people on that job. By accommodation, you want to look at the disability that it doesn't place an undue burden or hardship on the employer. If you have to bring an assistant in to work with the employee to do the job, that is unreasonable by almost all standards. It depends. But if you have somebody else paying for that, really, is that an issue? So pay attention to that. It could be a space issue. It could be the workplace has to be totally revamped. There are issues that are there. What is reasonable? Removal of unnecessary restrictions or barriers. Okay, if there's a barrier there that's not necessary, maybe that could be removed. This is where the good sense of the employer is, and make certain that you have the person working with them really does have good sense, because you have to be able to defend the reasonable person concept. It's reasonableness. Is this reasonable? Well, no, we have to sit down and change this. It's going to cost us $32,000 to modify the room over here and the workbench over here on top of it. So is that reasonable? No. If you're spending even close to what the annual salary is, of course that's not reasonable. So pay attention to what actually is the financial threshold by federal law as to how much you have to spend to accommodate that, but also use the sense of common sense or reasonableness that really is applied when we talk about Title VII cases. So pay attention to that. Here's the actual legal language right out of the book itself. The term reasonable means any modification or adjustment to a job application process, any modification to the work environment, any modification or adjustment that covers the entity's employees with a disability to enjoy the same benefits and privileges of employment that other people have. Use the concept of reasonable and be reasonable about being reasonable. So pay attention to that. I mentioned previously, I had a bus driver, and she really didn't have a disability. She was just short. We made an accommodation for her, and she was a sterling employee. So pay attention to that. If you have somebody that can be creative about modifying the work environment, go and listen to people. Now, by the way, that modification to having a short person driving a big school bus, that wasn't my idea. It was really the guy that was in charge, my chief maintenance worker in that area. He was brilliant, he was clever, and I said, "Are you serious?" And he said, "Yeah, I can do that." So we did it, and we made her drive around the parking lot, drive around the block a couple times, and she did it, and it was easy enough that he did it, and the whole cost was about less than $50 to make that modification, and I had a bus driver in a hard to fill job that lasted for years and years and did a fabulous job. Pay attention to what reasonableness really is, because of the fact that sometimes you may have to sit down and reach out and talk to other people that are more familiar with the daily routine on the job to make that happen. If it's possible, if you really are looking for that, can you restructure the job? Can they go part-time? Can you introduce somebody part-time on a disability to come in and work part-time and see if they can work into the job gradually? I've had another person who I hired as a night custodian, and he had a disability. He had no short-term memory. Now, that doesn't sound like much, except for the fact he caught Lyme disease. It ate part of his brain, and that aspect of it, he was a brilliant machinist. He simply couldn't do that work anymore. Well, I needed a custodian. He looked like a good worker, had a good background, except he had a disability. One night we came in, and we occasionally would actually go through and drop sawdust in an area. He forgot what he was doing because of the fact he had to have notes and everything. He had to have a note as to how to get to work for the first 45 days in the job, because of the fact that it had to go from the short-term memory, which in his case didn't work, to the middle-term memory. It was actually an organic function in the brain that he had to overcome. So one time, all of a sudden, the whole third floor in the giant building was covered in sawdust because he forgot what he was doing. We had to get the whole crew up there. It was laughable, except if it was in a crisis situation. Unfortunately, that wasn't a crisis. Everybody pitched in, but pay attention. If you can make an accommodation with somebody, figure out how you can go about do it. Sometimes the accommodation doesn't have to be the best. Sometimes it could be okay, long as it works. In that case, we had a guy. Yes, it wasn't the best solution if I had an employee with a full memory, but he had worked for many years in that job and did a relatively good job, and it was a change in his life. But we had to pay more attention to it, and nobody really cared, especially in the aspect of the way he responded to everybody else in the process. A disabled employee entitled to some kind of reassignment sometimes. You can actually put them into a vacant positions, but if they can't perform the duties, if they go back into it, there's no guarantee of placement in the process. So pay attention, look in the aspect of to how you provide an accommodation. Pay attention to Brown versus the Milwaukee School Board in the process and see what happens with that one as well. Undue hardship. It includes accommodation. It can be very expensive in the context, unduly expensive, substantial, or disruptive, or which fundamentally alter the nature of operation of the business. You do not have to change your business because of somebody that has a disability. You don't have to accommodate them if it's not reasonable. So the business doesn't have to go through an undue hardship for one person to make an accommodation. And here is actually the definition of the EEOC regulations that deal with how we define what is a hardship, the nature and cost, the overall financial resources involved with a reasonable accommodation, the overall financial resources of the covered entity, the operation and type of operations. And I advise you, if you have somebody in a challenging situation that has a new disability, you don't know how to deal with it, make certain you have proper legal counsel, because of the fact if you do this wrong, it looks really difficult in court saying, well, this person did the job before, and because they have this injury, and all of a sudden you're in the witness stand, you didn't do your due diligence in the process. You need to sit down and make certain that you have had a good dialogue with them and try to make an accommodation if you can possibly do that. There's tax incentives sometimes that you can have, so check that out as well. What is reasonable accommodation? And sometimes you might get a contingent worker that may come with a package of funds available to sit down there and modify the actual workplace. So pay attention to the cases of Ferrari versus Ford Motor Company and Palmquist versus Shinsky. By the time you're looking at the aspect of disparate treatment, okay, make certain that the employee has a prima facie case of disability discrimination. Here also, the EEOC, they're supposed to be assisting the employers, and they provide a whole series of different aspects as how you can go about and provide what we call the interactive process or discussion. Well, once you have that, the interactive process is here. Meet with the worker. Now, by the way, do this. Don't be afraid of it. Okay, the first time I did it, I didn't know what I was doing. I was coached by an attorney to go through it step by step. It is not tough to do. It's called talking to somebody. Meet with a worker, sit down and take notes. If you're the one talking, have somebody else be the note taker. Discuss alternatives, look at accommodations. It might be getting out of the room or out of the office you're talking to and going right to the workplace and looking at, well, what about this? What about this? What about this? And have the dialogue. Document the process. Put it in writing. Put everything. Even if you're making the accommodation that they want, put it in writing. Make certain you take notes in it, because this might be critical if you ever do get sued in the process. And it may not be that employee. It could be somebody else's. Well, you did this for her. Was that because she's a woman? Oh, no, that's not why we did all this. But what? How come you can do that? It's a different case. Oh, no, but you want to sit down and document the process and make certain that each time you make some type of accommodation, you have notes to show that I did this because. So, to close this section on accommodation, can the person do the work? And if not, is there a pathway to do so that is reasonable? Does it fundamentally change a job? Go through that interactive process. The directions are just before you on the PowerPoints. It's easy enough to do, but if you have any questions, do not approach this area without legal counsel if you feel unusually difficult about the job and would an accommodation actually alter the job itself. So pay attention to this. It's a wonderful opportunity to bring disabled people into the workplace and have some good, solid employees that may last a long time. But you also want to make certain that you, as an employer, are not going through an undue hardship to make that happen. Take care.